we've had a very fruitful first panel discussion here, and we've touched upon some topics such as Napster and the issues which music industry faces considering royalties and all of that. And this session is dedicated only towards music industry. The session is titled Copyright and the Music Industry. For this, we have three amazing panelists here and Aparna Gaur as our moderator. Aparna is a leader at the IP and TMT team at Nishit Desai and Associates, and she is also a registered patent agent. An experienced advocate, Aparna is active in IP transactional and advisory work. She has vast experience of advising clients over a wide spectrum of industry in relation to protection and enforcement of their IP. Today, she'll moderate the second session. We welcome you, Aparna. Our first panelist here, Pragyan Sharma, is going to be present with us virtually. Pragyan Sharma is an independent legal counsel, and he appears regularly before Supreme Court, Delhi High Court, and various other high courts and tribunals all over India. He has a wide-ranging experience of over various fields of law such as power, automobile, and media and entertainment. This by no means is an exhaustive list. He has extensive experience in handling matters for PSUs and government of India and various states, including matters in standing capacity of capacity of standing counsel in the Supreme Court of India. Welcome you, Pragyan. Our second panelist here is present physically with us, Pooja Uday Bakshi. Pooja is the head of legal team at Sony Music Entertainment Private Limited. As the legal head, she has dealt with many matters regarding music industry, and she's someone who has been adapting rapidly to the constantly evolving field of music and media and entertainment landscape. As an individual who has dealt firsthand with various issues, she'll be a guiding light for us in this session. We welcome you. Our last panelist, Atul Churamani, will be present with us virtually, just like Pragyan. Atul is the managing director of Turnkey Music and Publishing Private Limited, a company which was founded by him. He's a veteran in the music industry, and he has been closely associated with the development of Indian pop music scene and establishment of digital music publishing business for the industry. One only has to look at the illustrious career in which he has launched the careers of artists like Baba Sehgal, Daler Mehendi, Shan, Colonial Cousins, and many more. He'll bring a wealth of experience to our panel today, and we are very happy to have you here, Atul. We welcome you. With this, I would hand the dais and podium to Aparna. And
a round of applause for all the speakers.
Yeah. Aparna.
Hi everyone, thanks so much for joining us. Yeah, it's on. Yeah, thanks for joining us. We'll be talking about issues, faced by the music industry with respect to copyright. Honestly, when we thought of having this session, when we thought of a music session, we really thought that it's something, there's so much that's, not clear with the law that we can do a full one-day workshop on this. But we'll try to cover as much as possible within the 1 hour that we have. Atul, unfortunately, is unwell and he's lost his voice, so he will not be able to speak, but he's been kind enough to share some thoughts with me on email, and I will be sharing them with you during the course of the discussion. So I'll begin with the session, and since we have some students also with us, I'll start with Pragyan. And Pragyan, I'd request you to maybe deal with just the basics of when we talk about a sound recording, right? Who are the different stakeholders that we're talking about, and what exactly are their rights when it comes to exploitation of a recording?
Hi, good evening everybody. Actually, Pooja, thank you Gauri for making me a part of this amazing seminar. So, really nice of you. So, I think you have asked me two questions. The first being stakeholders. Who are the stakeholders and what are their rights to primarily? So, coming to answer the first question as to who are the stakeholders, we would first have to understand what is a sound recording. So sound recording is basically not a copyright as such, but it is a derivative right which has been deemed as a copyright under the Copyright Act. Okay? So therefore, we have to see what are the actual copyrights in a sound recording. Now, so these rights which are within the sound recording are known as what are the underlying rights, and I'll come to that issue. It's a separate question and a separate issue altogether. So the underlying rights that are there are the literary right and the musical right. Okay. So now the stakeholders in terms of section 2D primarily would be therefore the authors. Now there are different authors or different category of people who are the authors as far as the sound recording is concerned and as far as the literary work and the musical work is concerned. So as far as the sound recording is concerned, because the sound recording is created by the producer in a studio, so therefore the producer is the owner of the sound recording. Okay, so there is no doubt about that. As far as ownership is concerned, undisputedly, it is the producer, or from the producer today the music companies, Pooja is smiling all the way to the bank. So they are the owners as far as the sound recording is concerned. However, what has happened now, and as far as the literary work is concerned, it is the author, the person who writes the lyrics. For example, in a song, say Javed Akhtar Saab is the author of the lyrics. And when you come to the musical right or the composition, it is the composer. So therefore, technically in a sound recording, there are three kinds of stakeholders as such. And why I say stakeholders is because of the 2012 amendment to which I will come later. But as an industry practice, there were two categories of music. So one is the Bollywood music or the film music as we understand, and thereafter there is the private albums. Okay. Now, as an industry practice, what used to happen earlier, the producers would take assignments from the composers and the author and get the entirety of the rights as far as the music is concerned. And these rights were thereafter transferred to the music companies for exploitation in their way. So, therefore, in terms of section 17, for the entire gamut of rights, the producer or the music company became the complete owner. Because unless and until there is a contract to the contrary, which from more or less there were none, till people like A.R. Rahman, etc. has come in, there were contracts to the there were no contracts to the contrary, and being all these contracts being contracts of employment or contract of service, as they say, therefore the producer became the first owner and had ownership of the entire gamut of rights. Now, interestingly, what has happened in 2012 amendment, an interesting proviso was brought in to section 18 of the Act. Now, as you all know, section 18 deals with the right of assignment and under what circumstances assignment can be done. Now, what it did, it brought in third proviso and the fourth proviso to the Act under section 18. Now, the third proviso dealt with the sound recording in a cinematograph, and that is basically the film music, as we say. And the fourth proviso had the sound recordings as far as the music which was outside the cinematograph, the private album. So what it basically said is that it should not, basically what I'm trying to say is that if you can just pull out that the third and the fourth proviso, it will make things very clear for the participants here. Yeah, so slightly above that, yes. If you come to the, yes, that's the one, you can go down slightly so that both the pages can be seen. Yeah, this is the last one at the page, is the one that deals, this is the third proviso that I was talking about, that deals with literary or musical work included in the cinematograph. Now, what is the underlying fact here? What it says is that the person, if he assigns it to any person other than his legal heirs, it shall be void. And if you go to the one below that, that is the fourth proviso, it says the person assign, he cannot waive his right to receive royalty. And in case there is an agreement to waive off the royalty, that agreement would be void ab initio, or that agreement would be void. So therefore, what it entails is that for exploitation of the sound recording, the royalties for other exploitation would be shared on an equal basis with the assignee of the copyright. Okay? So therefore, in terms of these two provisions, the law has come to more or less settle, or the practice has come to more or less settle, that the producer or the music company is the complete owner of all music, but in terms of royalty, or the, if I say the stakeholder in a way, the author and the composer would be also a stakeholder, maybe with a lesser right, that is of the right to receive royalty. Okay? So these are the, so basically, if you therefore are to answer your question, technically the first right is of the producer of the music company, and the second run of stakeholders will be the authors and the composer, who are the literary owners, or the authors of the literary work and the music as well.
Thank you for that, Pragyan. One more follow-up question to this. There's also performers, and the Copyright Act specifically recognizes performers' rights. And with respect to music, obviously there's singers who are there, and there's copyright societies dealing specifically with rights of singers. Do you want to just deal with that aspect as well, and what exactly are the rights of performers with respect to a sound recording?
Very interesting, because there's been a lot of developments, and Pooja, if you can take out the definitions of performer and performance in 2Q and 2QQ, I'll start from there actually to answer your question, because this is something very, very live and something very interesting, because the litigations in the Delhi High Court with regard to performers and rights have just been settled. The music companies have withdrawn, or ISRA has withdrawn those cases. 2Q. So first I will come to 2QQ, and then I will go to the right of the performer. So if you see, who's a performer? Performer can be a singer or a musician, but please underline the words who makes a performance. So that makes the definition of performance very, very important. Now, what does performance say? Performer in relation to the performer's rights means visual or acoustic performance made, please underline this, made live by one or more performers. Now, the question therefore is, if it is a live performance, it is only in those circumstances that a performer's rights, which is there under section 38, kicks in. Now, we all understand what is a live performance. Live performance is when you go onto a AC/DC or a Guns N' Roses concert, or a concert of, we went to a Jugalbandi concert of Amjad Ali Khan and Zakir Hussain. So that is a concert, that is a live performance. So the recording that is done in that live performance, the performer has a right for any exploitation of that. Okay? But what happened? The 2012 Act brought in certain interesting changes in the way the performer's rights were to be interpreted. And just see, therefore, section 38. Section 38 with some amendments have been made. There are some amendments that have been made. But what is important is 38A. Their specific rights have been given to the performer under the 2012 Act. 38. Now, as you all know, performer's right is not a copyright. It is like a moral right, it is a special right that is being given to the performers under the Act. Now just go one step above into section 38 per se, and then we'll come to 38A. Yes. 38, yes. 38, yeah. Where a performer appears or engages in any performance, he shall have a special right to be known as performer's right in relation to such performance. So if you see, if you go back to the definition under 2Q, this performance, please mark again that it is only a live performance. Okay, now let's read performance. What are the rights of a performer? 38A, therefore. Now, so it's interesting. Therefore, what it says is without prejudice to the rights conferred on authors. So, the author's right, okay, that is maybe a producer's right or the the author in a musical work, that is the composer or the author in the literary work, their rights, protecting their rights. So, their rights have a prominence here, and without obstructing their rights, the performer's rights will come into play. Okay, that's my interpretation, and that's probably the manner in which we have to read section 38A. So, is an exclusive right. It says that is an exclusive right to do or authorize the doing of the following acts which are there specified in A: to make a sound recording or a visual of the performance, including communication to public. Okay. So, and if you see subclause 2 says that if it is, now, if you see the performer has by agreement consented to incorporation incorporation of the performance in a cinematograph, then the producer will have all rights in the film. But then, if you see the proviso to that, the performer shall be entitled to royalties in case of making a performance or commercial use. Now, interestingly, what has happened now is that if you read the act, the intent of the legislature while making this act seems to be clearly that the royalty or the right of performers kicks in only in respect of a live performance. Okay? But interestingly, what the copyright rules that came in 2013 did, it sought to expand the definitions of the scope of section 38A. Probably that was the intent, but they did not change the definition of a performance in this thing while contemplating section 38A. Just see the rules. If you have the rules with you, do you have it? Yes. So just take out the rule 68 for a moment. It's very interesting, therefore I want you to refer to that actually. So go to the three explanations which are at the bottom of this. Okay, so the first explanation says that royalty collected from the enjoyment of a performer's rights so and so shall be shared equally between the performer and the owner of copyright. No difficulty with that. So therefore, only with explanation 1, what happens is that the performance which is live, any royalty collected out of that gets shared between the owner, that is the producer, and the performer. No difficulty about that. See the second one. Now, commercial use also means exploitation by way of reproduction, by communication to public by broadcast. Okay. Now the question is, if it is only live performance, where is the question of bringing in communication to public by broadcast? Because when you bring in communication to public by broadcast, you are departing from the rule of live performance. You are getting into a studio kind of a recording. And that is what is clarified again in explanation 3. Again, very interesting. It says for the purposes of this chapter, performance includes recording of a visual or acoustic presentation of a performer in the sound or visual recording in the studio. So, it does actually, the rules of the explanation, what it does, it has expanded the scope of the whole gamut of the right of the producer. The question therefore that arises, and it's very interesting, that can the rules expand the definition of the scope of a right which is provided under the Act? We have several judgments of the Supreme Court which clearly say that the rules cannot expand the meaning of the Act. So, to my view, therefore, these rules are contrary to the Act. Now, exactly these arguments have came up before several litigations filed by ISRA and a lot of music companies like Saregama, Yash Raj and TCVs filed intervention applications before the Delhi High Court. Now recently, and Pooja will clarify this because she has all the internal news and gossip, there has been a kind of a settlement between the various stakeholders, and I don't know what the terms of. Pooja will, if she has the authority, she will disclose all of that. So there has been a settlement where from the collections, the performers will also get some kind of royalty out of the broadcast of the sound recordings. That's who are the performers.
Sure, thank you so much. I think what basically comes out of it is there is definitely lack of clarity in the letter of the law. So Pooja, on that note, I'd like to ask you as someone from the industry, has the industry faced issues in implementing what the 2012 amendments brought in?
Hello? Hello?
Yes, yes.
Thank you. Okay, so yeah, that's true. Lots of things have happened post the amendment, and because of that, lots of issues have been faced generally, I think, by the industry overall. Taking from where Pragyan is left, I think it's important to probably start with performers, since we are anyway discussing it, as well as whatever is related to the royalty payouts for authors. Okay, I think primary issues were these two, which actually, obviously, okay, let me put it this way. Three issues are really important. One is the term utilization, that is there for authors and composers, that has been used under 18 and 19. The second is related to the similar issue for performers. Once performers got introduced in, the issue came out as whether they are actually copyright holders or not, and what is the rights that the performers have, what is their level of rights that they have. Okay. Third is the issue of 31C and 31D. Now these are the three variant major changes that came about, which have led to a lot of discussion, a lot of debate and a lot of litigation to a large extent post the change of the Act. Okay. Starting with utilization, now I think the issue is that most authors face this problem, or let's say the industry is facing this problem on the interpretation of the terminology utilized in 18 and 19. It's so wide, it doesn't say clearly what it really means, utilize in which form. And now, like we discussed in the earlier panel discussions, NFT, etc. have all come in, right? So loads of modes of exploitation have set in. So what is utilization? Anything is utilization. Whereas if you look at it, I mean, maybe I'm kind of reducing it or just giving a simple sample of an example. If you look at it overseas, like a PRS, etc., when they consider utilization for payables to authors, they look at it from the performers or the communication to public concept. And that's how IPAB or anyone else has also dealt with it when they've introduced the royalty payouts on the 31D. Okay, but the issue primarily is that the terminology in the Act is not appropriate. It doesn't clearly restrict or say that is what it is. It's just very wide. So I think conceptually that is where I felt was an issue of concern. I mean, in the sense, obviously it's a great introduction that the authors are entitled to royalty on all utilization, and that is, I think, always what the intent is. In fact, as a consequence of this, I think even the introduction on the mode of medium is quite redundant, because today there is a royalty structure set for all authors to be paid continuously, irrespective of whatever mode of medium is being introduced. So therefore, I don't see that sort of an aspect is of concern. But this terminology has led to litigation and a lot of interpretation. In fact, this has also led to the litigation where we are all under debate on whether sound recording entails usage of literary works or musical works or not. And that itself has become a bigger litigation, because today I think even in the broadcast section that is under debate, which ideally, since we all thought or believed that communication to public or broadcasting would entail a right, the very fact that that is being challenged today in Supreme Court or is under appeal is an issue of thought. And more so now, post the amendment of the Act, the interpretations as per 2012, I think even the earlier judgments were very clear on the fact that let's just read. I mean, Pragyan, I'm sure you can add on where the judgment issues are there. But I felt that the issue that which I thought we should just discuss is that definitely these are independent works. They definitely form part. The very fact that the act is amended and now there's a royalty payout for it, that means there is supposed to be payment made when they're used. So to say that they are independent but we are not recognizing its existence when it's forming part of a sound recording, I feel that that may not be the most accurate of interpretation, because let's assume it the other way around. Today if you assume a literary work or musical work is infringed when creating a sound recording, you do raise an issue, right? Don't you say that, well, this is wrong. How can you use a literary work or musical work which is copyright infringing in a sound recording? Because you acknowledge the existence of that work in that sound recording. Similarly, to say today that that work isn't relevant is inappropriate. In fact, today, since there's a change in the Act, post 2012, it says there's payable royalty on the usage. That means they are also recognizing that it exists as part of a sound recording. Similar situation will arise when a sound recording is featuring in a movie. The same situation arises. So I guess that is one of the bigger issues that have arisen, utilization, the wide gamut. And the other issues also, when they say the word is equal. Equal to who? Equal to what? Assigned what? It's also complex. I'm maybe mixing a few things here. It's a little complex vis-a-vis when you look at it from performers. Today you're seeing performer will also attract 18, 19. So equal in what way? A performer has to be paid equal, author has to be paid equal, and a music label who's a publisher also has to be paid equal. Then how are you paying this money? Clearly that aspect hasn't been really looked into from that side. Other than that, equal is something, equal from which aspect? Even a music label does not get equally all the money. Half money is retained at different levels, at different places for different levels at utilization. So when you say equal, at what source is it equal at? So there are lots of commercial angles when you say equal, I think that is one more aspect that should be considered. I think that's one of the things. Also, if you look at PRS or you look at how UK law treats it, right? There they clearly call it equitable remuneration and they refer to it as performers royalty. And I think PRS is very clear that the royalty payouts on the usage is on performers. And I think that law is a settled law utilized by them for a long period. Their law, I think we have reached this sudden age, we've jumped 2-3 sections and we've arrived at a law, whereas they've graduated to it. So I think there should be certain learnings on our part, seeing how they have arrived and why they arrived at that. And also the fact that the quantumization of it, when we think of it, as to what percentage or proportion of it, that will all be dependent on the modes of utilization of how the performance happens. Example, it would be important for us to assume if streaming is there a higher level of performance in it, or there is a mechanical component in it, then therefore the performance royalty should be paid. If digital is a medium, is digital a medium? I mean, there are several aspects that need to be considered. Again, maybe because of that, and also Tips and Mick is very clear that internet broadcasting is not part of 31D. Okay, taking it's a mix in my discussion. So if I'm heading from all directions, excuse me, you can always ask anything in that. But that itself will clearly indicate that the definition of broadcast, which is covering wired and wireless, and also that itself is covering communication to public, has led to this confusion in the interpretation, despite the clarity of 31D, which clearly says that it should have been restricted to the television and radio broadcasting. So, I mean, these are things which are open for interpretation, no doubt, but these are things which are currently there, which are a reason of dispute. Because of this, there are a lot of interpretation issues. And now, of course, this is the author level. The other bit I was touching was on performers. I think Pragyan just went in detail on the entire section on performers. If you see 38A, it's very clear. It clearly details out if you have a contract to the contrary, what is the position you should hold. It also clearly clears out what happens in a case of commercial use. That means there's a royalty payout there. Why is there a royalty payout there if you have an 18 and 19 section which is supposed to be read for royalty payouts? And why is there this parallel royalty payouts? What is the implication or indication of that? If that is the case, and today you are treating a performer right to be on the same page as a copyrighted work, though it's not copyrighted work, because you are saying you can't apply 14 to it, quote unquote, because it's for copyrighted work, then in the interpretation you also put a section where you detail out what a performer right is. You also detail out how the exploitation of a performer right is. then in that sense, how are you treating the interpretation for 18 and 19? And why is that on all utilization payable when that utilization clearly details out 38A as to what the utilization is or what that right is? I think that these are the sort of again issues that have cropped up which are little interpretation related. Yes, today I think because of all these issues and the global position also being different, worldwide, there has been some discussions with the industry and there's been attempt to arrive at something mutually so that it's convenient for working, like Pragyan mentioned, with the Singers Association, because the intent was never not to pay, but the intent is that how to pay, what to pay. There's a little vagueness in that, and I think that should have come out clearly somewhere. The third issue that I'm highlighting on is 31C and 31B. As issues. Again, like I mentioned, 31D I already highlighted. The broadcasting is the definition which is of debate, which has led to a lot of interpretation issues, which has led to even there have been circulars passed to clarify the interpretation. I guess that is of concern. Also, I guess 31C, it's great as an introduction to refer to what a cover version is in order to secure the rights so that there's no misuse of the rights of people and authors and content. But the concern is today, as per Rule 27, how are the rates being fixed, or what would be the rate structures that are payable to them, and what is the royalty that we have to pay for the 50,000 units if I want to make a cover version. And of course, I'll comply with giving a notice. Of course, it's mandatory that I should just give a notice and the rights will flow in. But if there's a minor adaptation, will the guy object? He may object under 57 anyway. But I'm just saying, it's still vague. It's not the most appropriate because the rates aren't there and I can't use this section. Though it's in play today, within the industry, we've accepted the position that maybe we can't use it right now, so we ourselves would not be in a position to make versions. However, you can see a lot of versions floating on YouTube, right? But the fact is that those are UGC and those are treated as versions for which licenses are sort of in some ways paid by the platforms itself, because they are envisaging that people will be using it. And that's how it's working today. But technically speaking, if I was to actually say, hey, I want to make that song and I really want to make it as a version to it, I'm today not in a position to do so since 2012 because I'm not really clear on how the rate will be fixed and what will the rate be. So I guess these were the real issues that we really faced on the industry level.
Thanks, Pooja, and thanks for breaking it into points, considering that we're thinking of making submissions to the government. I have one out of syllabus question for you. I'm sorry I didn't put this in the list, but since we've spoken about how rights, for underlying works are separate rights, what is your view on a separate license being required when a sound recording is being exploited for the underlying works as well?
So obviously this is in court currently, and it's in big debate also. And I think there are two aspects to it, and I guess both may be right and wrong because of the way the reading is. But really section 13 of the Act, with subsection 4 clearly says that they are both independent rights. Okay. Global position is that whenever any work is used, the underlying works are paid for. So in view of that, I mean, contrary to whatever, of course it's subject to whatever the final outcome will be in court. But obviously, if it's an independent work and it has a separate entity or a right, and like I mentioned, if for utilization you're paying, if for infringement of that work you're paying, then that underlying work has a value. And that work is an independent work, without which you can't make the other aspect. So I guess in some ways, that ideally would be also recognizable and ought to be paid for. It's definitely paid for independently. It's different that where a cinematograph film is playing, people are not paying independently for sound recordings. They rely on cue sheets and stuff like that. But ideally that ought to be paid for also separately.
Thank you. Pragyan, do you have any thoughts on this aspect about the license for underlying works? I think you're on mute. Sorry, Pragyan, you're on mute, I think.
So that's a very difficult question to answer considering I represented one thought process, but if you give me the brief for the other side, I can argue even for the other side. But I'll basically lay out as to how the controversy evolved. That's very, very important as to how has the controversy of this underlying work has evolved over the years. Now, what had happened is whole controversy dates back to 1977 when the Supreme Court, in a litigation filed by IPRS against two concurrent judgments of the Calcutta High Court, the division bench and the single judge, held that IPRS does not have any rights because IPRS consisted of the composers and the literary authors at that point of time. Okay, so IPRS consisting of music companies were not a part of IPRS at that point of time. Mind you, that's something very, very important. So they contested before the Supreme Court and said that cinematographics exploited in a theatre, my music or my composition is also exploited. So therefore, I have a right to royalty. Now, what the Supreme Court said, and as Pooja mentioned about section 13(4), because section 13(4) says there shall be a separate copyright. So technically, therefore, the cinematograph becomes a separate copyright. So, putting reliance on section 13(4), the Supreme Court said that once you have parted by way of an assignment or otherwise, your rights and your right to show that music or composition in a cinematograph, you are devoid of any rights. Therefore, the producer will become the owner of not only the cinematograph, but also the music that is underlying in that cinematograph. Okay? So that's one aspect in the Supreme Court. Now what happened is that controversies again started thanks to IPRS. IPRS had agreements with these various broadcasting companies like ENI or Radio Mirchi, Radio City and all of that. So one of the points, and this was our creativity, we said because IPRS had given huge infancy discounts to these music companies and they started booming into profits, etc. So we should not be giving you all this discount, these discounts are to be going out. And what they were doing, for example, if the music license was given for Mumbai, you could hear music of the same radio station up to Pune. This was before the second phase came in when Pune had a separate license, etc. So you say you are violating the term. This agreement was only for Mumbai. So when we raised those issues with the broadcasting companies, they came with a counter attack. They said, see IPRS, you being an underlying work, we don't need to take a license from you. If we take the license for the sound recording, that is good enough for us. So that matter initially went into an arbitration and also became a matter before the Delhi High Court, a matter known as Aditya Pandey. Now, as far as the Supreme Court arbitration before Justice Sujata Manohar is concerned, she held against IPRS to say that when a sound recording is exploited, the underlying works need not have a separate license. Because as Pooja said, once there is a new work, why do you need to pay for an underlying work? You don't need to, and that's the international practice as Pooja rightly mentioned. Similar view was held as far as the Delhi High Court single judge Justice Ravindra Bhatt's order. He also said a similar view saying that, look, you don't need a separate license. Sound recording is good enough, and that view was actually upheld by the division bench, a judgment of Pradeep Namrajog and Justice Malhotra. Against that, IPRS filed a Supreme SLP in the Supreme Court. Now, Supreme Court, by a judgment of Justice Pant and Ranjan Gogoi, came out with a similar view saying that no, you don't have a right, but see, the law has amended. It directed the single judge of the Delhi High Court who was hearing those suits, because all these observations of the Delhi High Court were interim orders. So you kindly dispose of the suit. Now, interestingly, what happened in that single judge, Justice Enlaw's judgment, he says that look, IPRS, even after the amendment, that was not an issue before him because he was dealing with the suit prior to the amendment. So he came up with the view that even after the amendment, IPRS would have no rights. Whereas the Supreme Court in its order had clearly stated and accounted for the provisions specified in section 18 and 19, which exploitation, etc., it seems, from a reading of the Act, on a deeper interpretation, that some kind of right on the utilization was given to the underlying rights also. Because that is otherwise it would make the word utilization completely redundant. So therefore, an interpretation or an argument can be made that once the sound recording is exploited, there is a utilization of the underlying work. Okay? So if there is a utilization of the underlying work, a license is entailed even for that, but that is a separate license. And the Copyright Act at several portions say of licenses who are sound recording and licenses who are musical and literary work. So obviously if you read the Act in a harmonized manner and as a whole, which is one of the rules of interpretation, then a sense I can argue, there is an argument that I can make out, that separate licenses are required. Now, interestingly, at the same time when the Delhi High Court order came, the IPAB, which was dealing with a section 31D issue on on valuation as far as broadcasting is concerned, gave a view that yes, there has to be separate royalties paid and separate licenses taken for both musical and literary right and a sound recording. So as Pooja said, this is an issue which is live and is now pending before the division bench. So you could argue it either way. So I am biased because I have come to represent a particular section of the music company side, but there are definitely arguments for the broadcasting side also. I won't say there are no arguments, and I think we had a discussion, very intellectual discussion. Gauri has a different view as far as this issue is concerned, and I'm sure I'll convince her over a cup of coffee whenever she's in Delhi next, that probably the law, in my view, as far as India is concerned, because India jurisprudence is slightly, there is a departure from the US or the UK law. So, as far as the Indian jurisprudence is concerned, I feel, and that's my personal view again, the regime will settle down at two different licenses and the underlying works being licensed separately. That seems to be more or less the understanding amongst all the stakeholders also. At the moment, presently at least. So that's where we are at the moment.
Thanks. I'll also quickly just share with everyone, the thoughts that Atul had shared with me. I had also asked him what are his thoughts about how royalty payments are working since the 2012 amendments, and his view is also that copyright societies are unable to collect monies, and then even payment from copyright societies to the artists or the owners of underlying works is not happening efficiently. So with that, maybe we'll move on to the concept of copyright societies. So Pragyan, if you want to maybe quickly just tell us just the basics of copyright societies and some issues that are revolving around copyright societies and that we are seeing these days.
I hope briefs that I might have are not taken away by answering this question, because again there are very interesting and live issues. But I'll lay down the areas and I'll not answer or give an opinion as far as my interpretation is concerned about these issues or what the law should be. That's for the courts to decide. Now, so basic thing is what is a copyright society and what is its purpose or object, and what are the issues arising out of a copyright society. These are the two things that I see as far as the copyright society is concerned. Now the first aspect is, what is a copyright society? The Act says under 2 FFT that copyright society is a society registered under the section 33 of that. Now the intent of why a copyright society is there is found in subclause 3. Now there are three stakeholders here. Okay, for an exploitation. First is the authors and the owners of copyright. That is one stakeholder. Second, for utilization, is the persons using it. They are the second stakeholders. Okay? Then there is a third stakeholder, which is basically the that is called, so therefore the intent and purpose of section subclause 3 was to protect the interests of the persons, authors and composers, as also the person seeking license. I'll give you an example. Now, there are various authors and composers and music companies. Now, is it possible for individual music companies, especially the smaller music companies, to ensure that they are getting the royalty for the exploitation of their rights? I'm not talking of the big players like Sony and other players, but take cases of smaller players like Aditya Music, or smaller players like, even smaller players like Gitanjali and all of those. Now, it is not possible for them to have a team of people to go and see as to where all the music is being exploited, etc. So a copyright society takes over as a collective organization to ensure that the rights of these people, of these smaller music companies, and also the bigger music companies, are protected and they have more bargaining power as a whole, rather than trying and going ahead and issuing licenses individually. On the other hand, the person utilizing it also gets a one-stop kind of a stop. So, for example, say you want to have an event in this, a seminar or whatever, but this is under the exemption. Suppose this was a commercial program and you wanted to play some music here. So obviously you have to have licenses. So you can't go to 100 different music companies and take licenses from each of them. So here was one body that you have to go to and take licenses. Now the interesting part, however, as to what it does is a copyright society brings in transparency also, because you have provisions in the Act as well as in the rules which mandates a copyright society to have a tariff. And that tariff has to be published. Not only does it have to be published, but it has to be also presented to the copyright registrar, right? So there is complete transparency as far as the tariff is concerned. So people taking a license knows that if I want a license, these are the kind of fees that I have to pay. I'm not getting into nitty-gritties of the discounts, etc. here that Pooja will explain hopefully in a non-official format. But that is what it is. That is what the law entails. But one interesting aspect, and that is an aspect which I feel will be a matter of litigation soon, and we will all be holding briefs as far as that is concerned, is if you see or if you put out section 33, the Act says that there shall be only technically one copyright society for one class of work. And anybody which is into the business, it says the Act or the section starts with no person or association can conduct the business of issuing licenses other than through a copyright society. It definitely has a proviso which says the music company or the company on its own can issue a license. But can a person who's into the business of issuing licenses can do so without being a copyright society? That's a major question that is going to come up, especially because when you have different people that you have to, for example, a person wants to utilize the music today. Does he go to one? He doesn't. He has to go to PPL, he has to go to Nobel, he has to go to 10 other people. Is that the intent of the Act? I ask myself that question. Especially in view of the non-obstinative clause that section 33(1) starts with. Beholds the proviso. The proviso probably contemplates a person like Sony to issue a license on its own. But can that right be given or assigned to a company which is exclusively in the business of licensing? Will it not be contrary to the main provision? So these are the issues that are going to come up, and hopefully it does for lawyers like us. So interesting issues there.
Right, thanks. Pooja, coming on this point itself, I wanted to ask you, do you feel copyright societies today are, efficiently doing what they're supposed to do, or do you think some reforms are needed? with respect to copyright society?
Yeah, so I think the copyright societies are definitely making a lot of effort to work their thing. But like how Pragyan said, it's a little tough for them because this registration is one of the issues. That I think the multiplicity of societies is another issue. Also, I think the concern is more so for such societies is if you see the DSPs today, they're not providing excellent reporting. If they did provide it, then societies could easily report back to the authors stuff which they need to. So that aspect hasn't been kind of factored in. Though of course we are referring to a single society for single class of work. Overseas again, I mean I'm just expanding. Overseas there may be multiple societies for similar class of work, but that leads to a lot of competitive rates when they're pitching for rates when another broadcaster or a television division or anybody goes and seeks out rates. I think that leads to a lot of competition vis-a-vis that. But from that aspect, I think in today's day and age, the societies are definitely making a lot of effort. Yes, we have a lot of challenges because in India also per se people are of the concept that you can use music for free. You know that, right? So I don't think that that's easy for even societies to deal with. And that's why they have to have legs, despite the fact that they could have just digitally captured it, but they still need legs on ground at different locations. So I think that is a very difficult thing. I think that primarily is the bigger concern. More than that, I think is the concept that most production houses or labels and things like that are not able to provide sufficient data appropriately to the societies. So I think the societies find it difficult to manage and provide all the data out. I think those are concerns. And obviously reporting is a very big concern. I think these are the issues.
So, do you think some sort of procedure should be set through which, say revenues, etc., or reports of exploitation can be provided to copyright societies?
Yes, definitely. I totally agree with you. There should be a procedure. Maybe there should be just one place where everyone can go. Even if there are multiple societies, there could be just one site where everyone can visit and go and select from whichever society they require whatever licenses. That would be a much simpler process.
That's right. Actually, we do, because we get this question so many times as to, okay, we're doing this and what all licenses and from whom do we need licenses. So yeah, that actually makes a lot of sense if it's all in one place and who owns what and
Correct.
From where
it's
do you
not like we're asking to reduce the rates.
Yeah.
Everyone will have the same rate pitching, but it's just easier for public.
Right. Okay, I'll move on to the next question, and Pragyan, this is for you. You've already briefly spoken about the decision of Justice Endlaw, wherein the judgment states that there's no need to pay separate royalties for underlying works. If you could just maybe spend another 2-3 minutes on this decision and what is your view? Obviously, it's in appeal right now, but what does this mean for the industry?
Yeah, so first of all, I need to tell everybody that this judgment of Justice Endlaw is stayed now. It is no longer a good law as such, and as I told you, it's in appeal. And I have already explained my view for that. Is that in my view, that I think the Indian jurisprudence entails, if you read the Act as well as the rules in a harmonious manner, I feel that the underlying works, which is there, the musical and literary works and the sound recording, entails two different licensing. And we realize this actually while dealing with a case with regard to section 31B. So since you have the rules, just see the rules regarding section 31B. I think if you see 30, I think, if I'm not wrong, I have done this matter a long time back. So if you just pull out 30, I think that makes it quite clear.
29.
Yeah, 31, sorry. If you pull out 31, and if you pull out 31.5, that seems to be definitely the intent of the government. The board shall, within a period of 2 months from the last date of receipt of suggestions, determine separate rate of royalty to be paid to the owners of literary or musical work and the sound record. Okay? So, what this entails is that two separate licenses are required and royalties, two separate set of royalties have to be paid. One to the sound record, to the literary and musical work, and to sound recording. So therefore, two licenses, two sets of royalties. So I think that's the intention of the government. Now, whether with an interpretation of the other provisions of the Act, you can have a reading of that. That's a matter of debate and argument. But on a personal basis, I think that is the intent of the legislature. Whether it has been made very clear or not, that's another issue completely. But this is my personal view on a harmonious reading of the complete Act.
Just adding.
And I'm open to questions from Gauri to answer this.
I think what maybe Pragyan needs to cover up is also that, example, if you assume literary work is an independent work, some musical work is an independent work, then the rates can definitely be fixed for them separately, depending on how will they actually be
used in a radio and television platform. That's what's important to be considered. Very less likely that literary work are going to be spoken in today's day and age, though that does happen. Or musical work is just going to be played as an instrumental music. But in the television medium, less likely to happen. So when you actually have a radio and television 31D section, I think that's one of the reasons why. It depends on the other vision of will that ever be the case, or will it ever be separate from the sound recording, or will it actually ever be separate from a cinematograph film. Though 31D doesn't apply to cinematograph film, it's restricted to sound recordings, literary and musical. But conceptually, sorry, go ahead, Pragyan, that's it.
Yeah. So Pooja is absolutely right. And in fact, that's exactly the challenge, because the IPAB gave two different sets of royalties for two different sets. The broadcasting companies have filed an appeal against this particular effect on these grounds, that you cannot have two licenses, and that's again, as Pooja said, it's a live issue. And again, whether this particular provision is only for instrumental music, which doesn't actually have the film music, etc. Those are issues that are to be interpreted and debated in court.
So just one more question, and maybe both of you can give your thoughts on this. With the abolishment of the IPAB now under section 31D and other sections under the Act, the royalty fixation, this issue will go to courts now, to the various high courts. What is your view on this, Pragyan, and then maybe Pooja, you can also step in.
I think see, I have been principally always very against this tribunalization of various things. I am completely against that. I mean, you started off with CAT, Central Administrative Tribunal, that you had the L. Chandra Kumar judgment, which actually upheld something like that. But the tribunals have come in only because the government wanted to take control over the courts. And I principally have never been in favor of that. And what now the government, the present regime is trying to do is either merge a lot of different tribunals and tribunals into one particular forum, or various jurisdictions have been given to the courts. So I definitely feel today, especially if you take Delhi High Court, we have one of the best commercial courts or the best IP sections today. And we have phenomenal judges. So I don't see any reason as to why the courts should not be a better option. Because as far as the Delhi IPAB is concerned, it still had technical people. Although, and technical people would be, some technical members would have knowledge of, issues emanating out of the Copyright Act. But some might not, some might be just an IS officer. But these Copyright Act and interpretation of the Act is at its infancy today. It's a developing Act. As you all know, it's a Cinderella legislation which is now growing into, one of the showstoppers, as I can call it today, because there's a lot of action happening as far as copyright law is developing. So at this stage, I think this is a very welcome move by the government, to take IPAB out and leave the interpretation of the statute to the courts. Because there's a lot of issues of interpretation which are involved today. And maybe once the law settles down, maybe For the issues as far as determination of royalty, we can have a specialized tribunal or an authority. But as far as the interpretation is concerned, I think that should definitely be in the courts.
Pooja, any thoughts on this?
Yeah. So no, I was
Just thinking he's absolutely right in the sense that we need to have some smaller body or any other body specifically focused on ensuring that the rates are fixed in. Also, the rate process is very complex. So I don't think the courts would have that much time to delve into all of that and to give those rates. And also the manner and methodology is very difficult. Like even in the last case of 31D, everybody arrived at an in rem rate, which ideally is unfair to all the authors as well as the work in concern, primarily because it's unique. Everything is different. Artistic value is different. So you cannot actually peg it at a certain rate and blanket it across. So I guess from that reason, yes, you do require someone, but yes, to debate it out, like you're saying. But I also feel that if you miss this stage, you miss an appeal, like I was just mentioning to Gauri, in the sense that ideally from there the appeal goes to the High Court, and then from High Court it goes again maybe further. But here if you're already there, then how will the process be? I'm sure it'll be complex, but that's what I feel. We do need that. Thank you.
Thanks. Maybe we'll do one more question for both of you and then open for question and answers. Pooja, one question for you, and actually you did briefly touch upon this, but today we're seeing so many remixes. Literally every song there is a remix. What are the various rights that are involved? You know, if someone wants to make a remix today, is it clear as to what do you need to do, who do you need to approach, and do performers have any say when it comes to, say, a remix of their song? Because we saw a recent controversy where a remix was made and certain people were not happy with the way the remix was made. So what are your thoughts about that?
So where artists are concerned, obviously the ones who's created the original work, they are entitled to their moral rights. How the interpretation happens of Section 57 is to the artist, frankly. So keeping that aside, I suppose, maybe if remixes are there and someone else wants to make it, you break it up into cover versions primarily. Cover versions will fall under 31C. That process, as I mentioned to you earlier, is complex. We can't deal with it. We can't make it unless the artist themselves or somebody sings it. The other issue is, as far as the remix per se concept is concerned, I guess the forums or platforms like YouTube and etc. have made provisions in their forms where they can cover disclaimers to enable people to actually allow them to make remixes and disclose what kind of remix or usage you're doing of a past license or for limited license. In fact, they're making available certain kind of licenses online for you to make it, provided you give them appropriate credits for it. Of course, the fact still boils down to the fact is what is a de minimis use. I think Anil touched slightly upon it, and what would be what is allowed as the limited use of the copyright, and it is without the actual copyright infringement, conceptually. So that is something where I think is the concern, primarily where most persons who are making versions or people using TikTok and all the other mediums arrive at. And I guess that is very detailed. One, I think we had an Yashraj judgment in 2012, which kind of detailed in exactly what those rights would flow, which I think have been reiterated again in another Super Cassette judgment recently in 19. But per se, there's the Berne and TRIPS conventions, which are very clear that there should be, and I would just like to highlight that there should be a special case why you want to make a recording. You should not exploit the original work, and primarily it should not be prejudicial to the person who's actually whose work it was initially. Obviously that is primarily right. You wouldn't want to hurt the person who created his work and would not want to diminish the value of his work. Of course, there are detailed 4 factors which have been set out, which I think everyone must be familiar with already. If it is work like we have under our section earlier, 52, if it's fair use, it's used for educational purposes, etc., then obviously it's allowed. So it depends on the nature of the copyrighted work that you're using, and obviously it depends on the quantum of the work, the heart that work is used for, what does it create, how much violation that happens, right? And the overall effect, in the sense, if that work, if it's a parody, how negatively is it going to be affecting somebody else, or how does those rights affect someone else's monetization of their original work. I think there are many factors which are looked into at court to really realize what a fair use is, and hence I guess this is a very debatable issue. tends to go to court if an issue does arise, because you can't really debate or judge on your own whether this has been, or these 4-5 factors have been captured appropriately or not. So primarily that's where it heads.
Thanks for that. Pragyan, my last question for you, and we did briefly discuss this, and about, a lot of businesses, music is being used almost by everyone, say for business events and parties within the premises, etc. And a lot of times people are not aware of the types of licenses you need, types of permissions you need. And one thing that we did discuss is maybe have one forum, one website, or a place where all these rights are whatever permissions are needed, whoever needs to give the permissions, it's all listed, right? Any other ways in which you think there can be more awareness can be raised about who to reach out to when you're using certain music, what are the exceptions, etc.?
Yeah. So of course, any kind of awareness is definitely welcome. For example, take the case of today's seminar or workshop. So this is again another step towards bringing in awareness amongst the various stakeholders and the students who will then pass it on to others. They will become consultants to various or advocates to various exploiters, person who is exploiting on music companies. So this is a form of awareness, and companies like, Pooja's company should sponsor events like this. So definitely, well, why not? So that brings in a lot of awareness. So next time, the MNLU should have sponsorship from all the music companies, taking it forward and bringing awareness. Having said that, licensing is a matter of law. And ignorance of law, as we all know, is no excuse. And let me tell you today, obviously the broadcasting companies have deep pockets and they have a huge plethora of lawyers advising them. So I don't think that there is any lack of awareness as far as the broadcasting companies per se are concerned. The other persons exploiting are the various restaurants and hotels, etc. There I understand some kind of ambiguity, etc. But they have the various federations like FHRI, NHAI. So these associations are there, and these associations have various lawyers. And I know it from a matter of fact that the associations have got legal advices, and these legal advices have been sent to all their members. So I don't think there is any lack of awareness in terms of the people exploiting it. The only problem is the intent. It is not about awareness at all. So the intent, as Pooja rightly said, you feel that copyright is something which is, it's a free lunch. That mentality has to change. And the awareness has to be brought in towards that, rather than in terms of the fact that you need to have a license. So that is the awareness I think that should come in the market, and that's where, I think all of y'all and companies like Sony, Universal, etc., and all the music companies and the others should push towards, that awareness towards the fact that you have to pay for copyright,
Thank you. I think now we'll open the floor for questions. Yes, please go ahead.
So my name is Linad. I'm a fourth year student at
MNLU Mumbai, and I have a question. So we were talking about underlying work. So in a musical composition, generally, like from what I have learned, I know that a sound music composer gets the right, but there are various other people like a sound engineer or a mixer. So what is the status of copyright for those people? Is any protection afforded to them in Indian law?
So I think the performer definition is quite wide, and I think they are covering all of them actually in it. It's different that at times all that work tends to become work for hire because the performer work is still assignable, you see. So all the performers can assign all their work, including the current performers, and so also the authors. So assignability is not an issue. Performers are entitled to royalty. Now the position would be whether they set up their own separate society like singers have, or are they part of the singer society itself. And if they are part of the singer societies, then they would be accordingly remunerated. That's how it would flow.
As such, and the sound engineers that are there involved with the composer while creating the music. So my answer to the question would be a clear no. the sound engineers and the other people who assist the composer in law have no right to royalty. It is the composer who has the right as an author, or rather, if I say right, the right to receive royalty. He is not an owner. So the right of the sound engineer and the other people who also contribute to the composition, the Act doesn't recognize that. The creativity or the creator of the composition is the composer only. This is what the Act entails here.
The one who gets the final credit, that is what I think Pragyan is referring to. What also does happen is that sound recording engineers and etc. tend to enter into
Separate agreements wherein they get separate royalties for their separate work.
Hi, my name is Murli Narasimhan. I have got this question both for Pragyan and for you, Pooja. There was a mention about IPRS. So, as a consumer, let me talk from the other side. So, I run a musical enterprise, and during COVID, we made an attempt to get a musical contest running online so as to keep the spirit and morale up of all the kids in the country who were confined to their homes. And it was during that, and the point that Pragyan mentioned about saying that it's not the question of awareness, but it's a question of intent. So we were aware that there is a law which says that you cannot use music, and we were already aware of laws of IPRS and music in auditoriums or halls like these or whatever. But there was no clarity about music in the internet space, in social media. And it was my attempt and multiple months of follow-up with IPRS and asking them questions on what is the kind of licenses that I need to take so that I can do this contest online. Because for any parent or a child, if it's a musical contest in an auditorium or a school or a hall, there is an X number of audience. But what happens online? So online, if there has to be visibility, it has to be on the social media. So what kind of tariff is there for an online publishing of a contest and all that? Multiple months of follow-up and still they had no answers. And at the end of it, there was just one plain statement given to me saying that we don't have clarity, so go ahead and do what you want. Now, I'm saying that we are in this age. So it's not a question per se. I'm just giving you a perspective of saying how societies need to evolve. If we are in this age, and internet is raging from so many years now, and we are all aware of the impact of social media and all of this, why aren't the societies are also keeping up pace with this kind of developments and getting the rules and regulations and acts much faster so as to help people who are already aware? So we are law abiding. We want to ensure that the law is, it's followed up and all the copyright royalties are given to the right kind of people, and we want to encourage the copyright societies, but they are not keeping up pace with the kind of requirements of the society. I'm sorry, I have an add-on question also. Extremely interested to know about anything about the Kantara Thaikudam Bridge controversy, if anything on that can also be given as an answer. So I've got two questions. One on the IPRS, it's more of perspective, and second is about Kantara, if you can elaborate on that.
I'm not aware of the second part of the question. I'm sorry, Pooja is aware, she can answer. But coming to the first question, I personally feel that IPRS as an organization has always been very flexible in terms of issues that are, I represented IPRS for some time, so I can say that. In terms of issues where public interest is involved. For example, you mentioned that you wanted to do the event for a public cause without there being any commercial angle to that, or to keep the kids busy. IPRS, as a matter of fact, gives issues licenses in such situations completely free of cost, and there is an exemption that is carved out for these as far as the process is concerned. But I completely agree. See, the whole Copyright Act and the industry is, even today, after almost about 14-15 years, it's still at its probably at an infancy. Okay, it's still developing. So there is a lot of lack of clarity as far as the newer areas of exploitation is concerned. For example, say metaverse or things like that. So definitely you are absolutely right when you say that society should catch up. And I have no doubt that IPRS and other societies would definitely catch up, and they should have processes in place to get anything to keep pace with technology. Absolutely, I completely agree to that extent.
So yeah, I think the whole reason
Be because again, touching the first point, I'm also not really clear about the other issue. But touching on the first point, what usually happens is that most of the distribution platforms or the social media platforms tend to take a license directly from IPRS, and as a consequence of which, whatever content you place on their platforms is already covered under those licenses, and hence you're able to enter into the thing and provide that stuff. However, if you're having a live event and it's a concert and there's a synchronization angle in it, then there's a separate license for synchronization that gets attracted, for which you would have to take a license from the respective labels whose content you're using on each case-to-case basis, which could be hard work, but that's the way it would be. So that's what that is as far as that's concerned. Yeah, sure.
Check. Hi, my name is Mandar Deshpande. I'm from Whistling Woods. So we, as academics, it's a very grey area that we play music for musicians in their academics for free, and then we'll ask them to charge for it. So it's like a huge contradiction happening there as well, because there is no clarity in context with what is free for education and what is not free. My question to you is, there is this new trend which we have been seeing as filmmaking institute, that many of them, they don't own the actual song right, but they will ask someone else to produce the cover of the song and then use the or remix the cover version. How do you see this legally? Like, is it like allowed, or what is the thing here?
So your question is a little complex in the sense, is it a cover version that is playing, or is it just musical beds that are playing and which are new versions that were created and other musicians are lifting that and creating their full songs?
Yes.
Is that what you meant, right?
Yeah.
So obviously appropriate license is required for that embedded music, which is just underlying, and there are separate rules of licensing which tend to be very small, so you can't really read them, but they're there. So you have to take that appropriate license from those people before you actually use such content. So example, if there's a production house and there are big singers, they tend to use musical instruments which have actually embedded music lying in that, and they don't tend to take the license. Then ultimately when I'm exploiting the content, that particular embedded music person can get up and say there's a violation. So yes, that is a concern.
Okay. The another part is when record labels are asking for, oh, you produce a video, and if you want like certain number of views or likes, especially with online streaming, your rights is mine. Like that kind of a contract has been seen with some of our students. So is it really possible for a label to own the whole right of the song, or the right is still with the author?
So section 17 clearly says who the author will always be, but their work is definitely fully assignable. So definitely it stands assigned if it is entered into a contract. Nobody can take away the rights of an author to be an author, right? So you have to recognize the fact that they are the authors, so they'll stay the authors.
Oh, okay, good, thank you.
Okay, if there's no further questions, maybe we'll end the session here. My only last thing I want to say is, unlike the speakers here, the law is not black and white, it's grey. So thanks everyone. Just wanted to wake everyone up because this was an intense session. So we'll break for tea, I think now, and we'll come back by 4 p.m. Okay, yeah.
Thanks,
go ahead.
Pragyan.
Thank you, Pooja. Thank you. It was lovely.
Before we break,
How do we get our saplings virtually?
Emmanuel, you to answer the question.
before we break, I would request Dr. Dhumane to felicitate Pooja.